Hello, everyone. Today's episode is about cross-border data transfers and cross-border data flows more generically. I'm Rachel.
I'm John. Hi, Rachel.
And this is Privacy Chats with Rachel and John. So, John, what inspired you to suggest this episode? I know I've made a mention to it, but what do you think that our listeners can get out of this one?
I wasn't expecting that question. What inspired me to think of it? I mean, I thought of it because it's a really important topic, I think, and it's one that's really topical. There's a lot of stuff going on that people in the background that people don't really pay a whole lot of attention to. So I think that's why there's just a lot going on. It's interesting to you and me because we're privacy professionals. And I'm guessing it's interesting to the people who are listening to us, because if you're not privacy professional or interested in it, you're probably not listening to this. So yeah, that's my answer to yours. What are your initial thoughts about the topic before we
I share those sentiments? Yes. I think, at least personally, as I was getting into privacy more as a study on my own time, it was kind of this black box concept to me. You hear cross-border data transfer, you have an idea of what that means, but you're not really sure who it pertains to. Is this companies? Is this countries and jurisdictions around the world? Like what are the concerns behind it? So I think we did a good job with preparing the questions that address what I would have liked to learn a few years ago when I was just getting into this. And I think it's an important foundation to have with understanding certain decisions that companies make, or, the criticisms regarding the gaps in existing legislation, especially here in the US. A lot of them, and especially concerns with overseas technology companies coming to the US, at least it's relevant in our jurisdiction. This provides a lot of the context for why those conversations are contentious and why we don't see, for example, more Chinese social media apps coming into the US up until now. And so I think, setting up cross-border data transfers as a conversation will help provide a better foundation when being a part of those conversations.
Yeah, got it. Okay. So I wanted to start off in some ways to kind of, I don't know, set the stage for this. I like to use analogies when I talk about things. So here's the analogy that I have for cross-border data transfers. So bringing it back into just like a family. So every family has little secrets and stuff. So let's pretend that a family has a secret about let's say a medical condition for one of the family members. And let's just say it's some sort of medical condition that it's sensitive and they don't want people to know about it, like the person might be embarrassed or something. So because of that, the family might agree, okay, none of us are going to tell any of our neighbors about this thing because we don't want, Sally to be embarrassed about stuff. But in the course of that, you might discover that you have a couple of neighbors who have some sort of medical expertise that might be able to help you, or so they can offer guidance or support in some way or another. So in that, you might recognize that of those neighbors, one of them is pretty trustworthy. You're fairly safe telling them things. They're not going to say things. One of them you really don't know well enough to gauge whether they're going to keep your secret or not. And the third one, that they're a huge blabbermouth and everything that they hear goes up on social media. So what do you do? So in that case, you might have a family meeting and decide, okay, we're going to tell the person that we trust because we trust them and they're going to give us good guidance and support or whatever. We're not going to tell the person that's a blabbermouth, and maybe we'll hold off on telling the other person, or maybe we'll make them pinky swear or something before we tell them, so we know that they're going to tell anyone else. In essence, what that family would have done is created a cross-border data transfer agreement, like this, setting up the conditions under which you're going to give this sensitive data out, beyond your border, the walls of your own household. So I hope that's my analogy to kind of explain what we're talking about, but on a global level. So instead of a family, we're talking about a country, and instead of neighbors, we're talking about neighboring countries. So I don't know, does that help to set the stage for this discussion?
I mean, I think so. And, analogy, of course, we can break it down in that this, family could be a country with some say over, data sharing practices, and the individual family member could be, in my interpretation of this analogy, a citizen of that country, right? So there's an interest in keeping it, the secret, this medical condition, protected based on, who you wish to share that with. And just because you do have other family members with access to this information and maybe some, privileged access, say in someone's, a caretaker
Right.
has some vested interest in getting this other family member better, right? They might think what they're doing is in good faith, but until you clear that with the individual with the actual ailment, like, is it really a true and universal agreement between all parties? I think that's a great setup and answers the question of why we're talking about this, right? Privacy has everything to do with controlling your own information, and where this, I think, runs into cross-border data transfers most clearly is the desire for countries to, yes, safeguard information, but also participate in conversations regarding national security or technological advancement. So both of those can mean they want to see more data than maybe other jurisdictions would allow them to, but would help further those efforts. Or in the reverse, you wouldn't want to share that such information out to perhaps prevent either your competitors on a more like commercial aspect, or other jurisdictions that you have perhaps conflicting principles with as a country, as a jurisdiction. I don't know, that's my interpretation of the analogy and how we got into the issue we're discussing. Something else that pops up with cross-border data transfers just becoming a more relevant conversation piece in privacy is just the advent of cloud technology, in all the means that we develop new either infrastructure or build upon what exists today. We're now in this, what I've read and I like to call the digitally borderless world. I know there was maybe, 20, 30 years ago, this expectation that, a borderless world truly exists and that there isn't an effective way to regulate data sharing or internet activity. But especially in the last 10 years, we're seeing kind of a reversal of that with understanding more about the benefits of technology, but also the harms associated with it. And technology is really built on the foundation of data, and because of the storage technology and cloud technology making those costs lower, you're now having more countries participate in that kind of economic imperative of development of key technologies that everyone around the world wants to use. But how do you control that when everyone has a piece and everyone really, in theory, can access the internet in the same way?
Yeah, and I think that has created it's caused countries to recognize that there's a problem. And I think a lot of these laws are new. Like, I don't know the full list of countries that have cross-border data transfer laws. When I was getting ready for this episode, I saw there's a fairly new one in China that just went into effect in 2021. I know Japan has one, and South Korea. Canada has a data privacy law that's more internal, PIPEDA, but it does include a principle, and I kind of jotted it down in my notes here. It says that an organization is responsible for personal information in its possession or custody, including information that has been transferred to a third party for processing. So that's all internal. And then it says the organization shall use contractual or other means to provide a comparable level of protection while the information is being processed by a third party. And a lot of people have interpreted that to mean, and I think correctly, that third party can be anywhere. So it's up to whoever has control of the data or is processing the data in Canada to make sure that if they're processing it or if they're transferring it to a third party, that there is a comparable level of protection, is the way that's worded, which I think meets the bar for being a cross-border data transfer stipulation, I guess, or regulation. And then I mentioned some of those. We've mentioned in several. Actually, it's probably GDPR has probably come up in every episode that we have talked about. And GDPR has the most significant rules about data transfer outside of the EU. There's a whole chapter dedicated to it. Articles 44 through 50 are all about data transfer. So there's a few of the countries.
Yeah, it totally reflects just broadly the European Union's more rights-driven regulatory model as opposed to like the US's market-driven regulatory model, and places like China's very state-dominant regulatory model, right? In the US welcome innovation, and sometimes that comes with data sharing, which I think is a very understandable reason why we haven't seen a national data privacy law here in the US, at least one that's not very sector specific. Now, I thought something was surprising, which is in my research, there was a paper I read that explained that there is kind of a spectrum of cross-border data transfer rules. There are some that are wildly strict, so you basically completely ban any transfers outside of your, home or originating country, and that is only seen in Australia, which I believe is for the most part a self-regulatory regime similar to the US's, but they actually require that no personal electronic health information is held or processed outside of national borders. And that's the only case on the most strictest version of data transfer rules in general across the world that's been examined to date. There's obviously the most lax, which is no restrictions, can do whatever you want, share whatever you want ever. I think the US honestly comes closer to that direction when we're talking about unregulated sectors. So I imagine banking, healthcare is kind of exempt from this, but those where data types aren't clearly defined, or like the practices behind it are not, required for the reason of, financial services or healthcare monitoring, like there's no rules, are there? I mean, not that I've come across.
There's not, and you're right. There are some references in some of those sectoral rules. So for healthcare or finance, or like even credit reporting, for example, or there are some protections for children. But there's no U.S. federal law that governs the flow of personal data out of the country. So really, what that means is any company or person from anywhere in the world who has legitimate, they already have to have access to the personal data. Once they have a legitimate access to personal data, they can take that and copy it, transfer it out of the U.S. To whatever country they want to. And a lot of processing happens in other countries because, like you said, it's a what did you call it? A borderless world, digital borderless world, or something like that.
Yeah.
That companies can process data anywhere, and there's some places that are cheaper to set up data centers. There's no restrictions. It's the Wild West, which is pretty scary when you think that, I think Americans at their core want their personal data protected. And in this aspect of things, it's just not happening.
Yeah. And, up to this point, our regulatory environment has prioritized innovation and strong technological development, with which, to your point, if we have cheap data store options that are overseas, that's a benefit to us that other jurisdictions might not have without those stricter requirements to, say, locally store or locally process data. So let's talk about the region or jurisdiction that has the most, publicly known and available data transfer restrictions, that of course being the EU and the EEA.
Yes. Okay. So where do you want to start with that? There's so many pieces that we can go into.
Yeah, we can start with, going back to GDPR in the way that it stipulates that data transfers can only take place if and when, that third country, I think to your analogy example, I'll try to use it in that term, say this is the second or third neighbor that hears from a friend, or, the individual that receives the information from the person that was still told about it, not the source. These third states can only, make these transfers if the protection.
There's certain,
there's certain requirements, right? And their term for this is an adequate level of protection, and it's otherwise known as the adequacy decision. I think of the shorthand of like, okay, is this adequate? It's a very straightforward kind of name for this. So if the level of protection is lesser than the standards imposed within EEA, member countries, then those transfers can take place if they're equal or better. If not, there are all these other options, degradations under GDPR, which are, as my understanding, basically exceptions. There are cases where it makes sense, again, like global investigations, imagine national security is part of that. But there's also other contractual mechanisms for this. But do you have anything to add on?
Well,
to
I do.
I don't want to take the whole stage.
No, that's fine. The it's a good way of looking at it. Like, what are the mechanisms by which data can be shared outside of the EU? There's really three. You mentioned the first one is about having an adequacy decision, and interestingly, they have, and it's required in their regulation that they create a list, maintain a list of the countries that have adequate data protection regulations. And if you're on this list, it just means that the EU recognizes that that country has, really strict privacy laws, and they're as good as or better than what's in the EU, and they really don't have to worry about data being transferred there.
Like
But
you're in the club, you're in that little family
exactly.
circle.
You're in the circle.
You've done
But it's
the pinky agreement.
the pinky swear, exactly. So but it's an interesting, and I think it's a short list. So it just includes Andorra, Argentina, Canada, but only for commercial organizations, the Faroe Islands, Guernsey, Israel, the Isle of Man, which I didn't even realize was a country. I thought it was just an island off of the west coast of England. Anyway, Jersey, New Zealand, Switzerland, Uruguay, Japan, and the United Kingdom and South Korea. So very short list of countries. And you'll note that the United States is not on there. So the European Union recognizes that the United States' practices are not adequate. They're not nearly close to what exists in the European Union. But the protections that they're looking for in the European Union actually go back pretty far. I should go back and listen to our previous episode about the history of Europe, and listen to exactly when the European Union became the European Union. But anyway, it goes back to, I know we talked in episode 1 and 2 about the OECD, and a lot of the privacy principles that exist in the world today go back to the guidelines that they published in 1980. And that kind of led to the Data Protection Directive in Europe in 1996, which then spun up this, it was called the Article 29 Working Party, which dealt with this problem of cross-border data transfers. So one of the things that they came up with was what was called the Safe Harbor Framework, which was a framework that, established what the requirements were of other countries to, I guess, demonstrate some level of adequacy.
Right.
That was enacted, I want to say 1998 or 1996 or somewhere in there, and stood for a long time. So, it was enacted in July 2000 and lasted for 15 years. It was struck in October of 2015.
Well, so something about the Safe Harbor Agreement, though, that I've learned through this research is that it was a self-regulatory framework, which means you basically like a test on your own to say, hey, yes, we've covered it. We've covered the concerns or the gaps related to your regulatory regime regarding, privacy and data transfers. So there was criticism at the time. I don't know if it was, around 2000 or sometime after that. Certainly there's enough toward the 2016 or 2015 mark, but it was recognized that because there's a self-certification, there's no compliance checks, no real strong enforcement with enough teeth to basically prevent violations of it. And I think I think it's interesting because we can identify, maybe a few scholars can call out these risks, but until you see the materialization of those risks, do we go back to the drawing board and say, hey, we need something new? I know you're getting into that, but that essentially did happen when a national security agency contractor, Edward Snowden, in 2013, exposed, how the U.S. wasn't abiding by those terms and agreement in his interpretation, having worked firsthand with some of these programs that did absolutely deal with data overseas. But I don't want to get into that too much yet because I know you're on a thought trail here, and I just cut you off a little bit.
No, that's fine. So the Edward Snowden thing was huge, and I don't think Edward Snowden had any of the privacy laws in mind when he did what he did. He just had access to a bunch of this information and recognized some practices within the U.S. government that he didn't think were right, and published those. I think after that, it was recognized in Europe that, hey, this disclosure by Edward Snowden really indicates that the U.S. security agencies have access to our personal data coming from the EU into the United States, and that's a violation of the essence of GDPR. The government in the United States shouldn't be able to look into that private data, and it was clear to them that that was happening.
You know, like, hey, the safe harbor agreement basically said you wouldn't be surveilling not just your own, citizens, but taking in data from other jurisdictions, because we did have a lot of the technological infrastructure that allowed us to intercept those communications, even if they were just bouncing from the US and going back to the EU. So it's understandable. I mean, it was in the name, a lot of the data collection activities that the US was doing was, of course, in the name of national security following 9/11, but Edward Snowden essentially revealed that, because this is happening without the knowledge of the public, and without certainly the public of other countries that are brought into this, it's, he risked his very comfortable, safe life as a security contractor, making plenty of money, very well protected here in the US, and, threw it all away to make that message be heard, and to hopefully generate, spark some conversation for change and improvement upon that. So that's where I'll jump in there.
Okay, yeah, you're putting him in kind of in a better light than I would be willing to. But
I know he's coined as a traitor, and he's definitely violated the Espionage Act by releasing what he did.
Right. I don't. I mean, let's not get too political, but yes, that's where I put him. And he lives in Russia now. I was reading about him today. He finally took Russian citizenship and has sworn an allegiance to that country. So yes, that's the completion of his traitorship right there.
Yeah.
Anyway, getting back to the point, the privacy aspect of it. So it wasn't, Snowden did what he did. And as a result of that, then it was Max Schrems, and I think we've talked about him. He, I don't know, filed suit or whatever it is that had to happen in Europe, which led to the safe harbor framework being struck down by the European Court of Justice, who has legal oversight over it. So they said he's right. The safe harbor framework is no longer adequate. So it was just struck down, to be replaced soon after that by what was called the Privacy Shield. It's usually called the EU-US Privacy Shield, which introduced more protections that basically said the security agencies in the United States either don't have access to that data, or there was mechanisms by which people could ask about it or ask for their data to be excluded from it or something like that. And that stood as the framework that existed just from 2016 until July 2020, when there was a follow-up lawsuit or legal action by the same person, Max Schrems. And that was called, so the first one, when Safe Harbor was struck down, it was called the Schrems decision, because he was actually named in the decision in the first paragraph by the European Court of Justice. And the second one, he came back, so it's called Schrems 2, the fact that the Data Privacy Shield was struck down. And I'm going to stop to see if you wanted to jump in on any of that, because that's covering a lot of time there.
Yeah. No, I think it's funny that these are called, Shrem, I guess one now that we have two. I think we both listened to the same interview with him on a different podcast, and I recall him saying that he didn't explicitly request or ask for these lawsuits to be coined or
called after him,
terminology named after him. He's like, it just happened, because my name was everywhere in the news because, I'm the source of this lawsuit. So I thought that was kind of funny. He was kicking up a big stir, but at the same time, he's like, oh, I didn't want to really I didn't need to be named after it. It wasn't an attention thing. But this is interesting, because I feel like, watching the timeline, especially the last 10 years, it seems to be a little ping pong ball that jumps from each side. We're okay with the agreement between the US and the EU, and then the Schrems lawsuits primarily so far come around and reject that. And it seems to be a continuous augmentation of very similar principles, but, addressing additional gaps that are identified through conversation about this. The 7 Privacy Shield framework, or 7 Privacy Shield principles, are nothing unfamiliar. It's notice, choice, the availability of onward transfer, security, data integrity, access, and what is most repeated to me throughout each of these versions is recourse, enforcement, and liability, and that's all supposed to be one principle. I think there's a lot of the concern with it being revisited is that there's not enough of a enforcement or a redress, basically like remediation mechanisms for those individuals impacted, which I mean makes sense. I truly wonder how that works out in practice, and is maybe an area to investigate further on at a later time. But I do wonder where enough is enough before either the U.S. reaches a point of, you know, developing a true comprehensive data privacy regulation, and if they were to, you know, whether that would satisfy the demands that we're
Adequacy.
seeing.
Yeah.
Basically put us in an inadequate position.
Yeah, well, I mean, the thing that replaced Privacy Shield after it was struck down is the data privacy framework. And I remember when there was I think an executive order was signed by
It's only last March. Yeah.
Yeah, well, it went into effect in October 2022, so just over a year ago. And it wasn't too long before that Biden signed an executive order, essentially establishing the U.S. side of that framework that then had to go be presented to the Europeans. And you know, I think the agreement happened in October of 2022, so just over a year ago. So that's what's in force now. So companies in the United States that are bringing data, like covered data from the European Union into the United States, are able to do that under the data privacy framework. But as soon as it was launched, like the same guy, we've talked about Max Schrems, he announced immediately that the data privacy framework is just the same as the safe harbor, as the Privacy Shield. It's just a new name on the same practices.
A little
so
lipstick he was on a pig moment.
Well, I guess, yeah.
From his perspective, right?
From his perspective. So, and I don't know, I think in the same podcast, the same interview that you said we both listened to, he was asked if he was going to, you know, go after this one. And I think he wanted to hold off. It sounded as if he was hoping that somebody else was going to step up to the plate this time. But he certainly, it seemed to indicate, the way the sense that I got was that he didn't agree with the framework and thought it should be struck down again. I'm not sure what he thinks should be in place instead of it. Like, he hasn't really offered anything that I've heard. I mean, feel free to correct me if somebody knows better. Interesting though, and I didn't realize this at the time, but I stumbled across it today, that in May of 2023, so just earlier this year, the European Parliament, which doesn't have authority over this particular thing, but the Parliament voted in favor of a resolution calling on the Data Privacy Commission in the EU to renegotiate the framework and not to adopt an adequacy finding on it. So basically, the European Parliament doesn't agree with the framework, which puts it on, you know, pretty bad footing.
Yeah.
So
stand still. We're on a wiggly little tile waiting for the next one to be placed. Sounds like.
Yeah, exactly. So it puts companies in kind of a precarious situation. I think the advice that a lot of I know companies that have authority over this stuff, or you know, that companies that other companies turn to for help. Yeah. That, like, what are we supposed to do in the meantime? And the other mechanisms that they can use instead of these frameworks is to have what are called either standard contractual clauses or binding corporate rules, are the other two ways. So I think they're recommending that, yes, use the data privacy framework, since that's the actual thing that's in place right now, but you should also have standard contractual clauses, which are, you know, really just contractual arrangements between the data processors and their recipients, you know, partners on the other side of the Atlantic, and these standard contractual clauses have been approved by the European Union. So basically, they're saying if you have these contracts in place that have these provisions within them that ensure the privacy, the protection of the data that's going over to the United States, then it's okay for that data transfer to occur.
I imagine these standard contractual clauses, or SCCs, I think, if that's a little shorter to name here, SCCs, BCRs. I imagine they're more customizable than, say, you know, a blanket rule or a blanket agreement, such as the Privacy Shield, or those that, you know, are meant to be the guiding principles across the board. Fortunately, I haven't seen one myself, but I'd imagine that because they can tailor specific requirements to different like process or relationship scenarios that might be the reason why it's somewhat of patchwork between the larger rules and requirements that are constantly being revisited, and therefore making it a good tool to kind of bridge you between when the adequacy decision can't be made, or if we don't have a mechanism to dictate that for a particular country.
Yeah, it's a good point. I would assume that the SCCs are editable, and certainly you would have to put the right language in there that applies to a certain situation. But I do think that they have been approved. So like I guess the boilerplate language in them has been approved by the European Union. So it's not just a case of that you have to have a contract that says that there's going to be protections, like whatever protections are expected have to be written, I'm assuming, in a certain way in those contracts that have been approved by the European Union.
Yeah, I believe there's also what are called transfer impact assessments required under Article 46 of GDPR. So that is meant to supplement like these agreements to show, hey, like this is we've assessed any concerns that either party could have raised about this transfer, and both parties are aware of it, and it's something I imagine you can share with the European Data Protection Board as well.
Yes, yeah, I think so. Sorry,
We go on different rabbit holes, I understand.
Well, we do, and I've got so many tabs open in front of me here from the research that I was doing today, and you said Article 46 and I went right to it.
Yeah.
Sorry, rabbit, squirrel, I'm back.
But do you have any more to say about BCRs? Because this was probably the most unique area for me. Is it's not as familiar in articles and public conversation, but I know it's an option. So that was a bit fuzzy for me. What did you pull out of that?
Well, I didn't. So when I first read about the SCCs and the BCRs, the binding corporate rules, was when I was studying for one of the IAPP privacy certifications. And so, I'm going to simplify it in non-legal terms, because I'm sure lawyers probably, if they listen to us, are like, no, they're getting this all wrong. They don't know what they're talking about. Right. So, again, we're not lawyers. We don't pretend to be. So my understanding is that the binding corporate rules are essentially for corporations, like multinational corporations, that it creates a framework within the company and all of its subsidiaries that are part of this transfer of data, that if you have these rules in place, that it's essentially saying that you as a corporation are operating in a way that ensures the protection of the data that's coming from the EU into your country. So, and those are rules that kind of serve as an umbrella across your company, and they're binding to the practices of your company. So, and that differs from the SCCs, the Standard Contractual Clauses, because those clauses are governance over the particular part of the company that's doing the transfer of data. So it's really covering just the data that's being transferred from the EU into the US. Whereas the binding corporate rules really just cover more of the practices of the company overall.
I see. Yeah.
That's the way I understood it. Now, when I was talking about recommendations for companies to have stuff in place today, because of the possibility that the data privacy framework may fall in the future, it wasn't recommending anything about binding corporate rules. It was just the guidance that I was finding was only talking about having standard contractual clauses in place. So I'm not sure why the BCRs weren't elevated to the same level of make sure you have those in place just in case also. But I don't think it was something that, companies wouldn't do both. If you have a binding corporate rule, I don't think you need the SCC. So it's kind of one or the other.
Something else I've read about binding corporate rules, I'd assume this also perhaps applies to SCCs, is that it's not a cost-effective or scalable way to, protect worldwide operations with their processing standards and agreements. It seems to be very case by case. So I understand that gets difficult if you don't have a higher overarching framework to follow and agree to, and basically attest your compliance to, but instead have to write contract after contract about all of these operations you're doing. It didn't seem very scalable. So thus the need to make that a backup and hopefully rely on something more universal as your primary mechanism to declare adequacy.
Yeah, I do. And I remember it was before the new data privacy framework came into place, and I attended it. It was a networking event that was hosted by the, I don't know, the DC chapter of IAPP, or like one of their knowledge net chapter meetings.
Awesome.
And they had a speaker there representing one of the U.S. security agencies, and they were talking about the protections that were put in place. Like, what were the differences in the U.S. data privacy framework that, you know, kind of satisfied what was missing from Privacy Shield before it. And I came away, you know, I'll be honest and say it sounded cumbersome. And there were pieces of it that I didn't quite get, because it had provisions, for example, that anyone in the EU who suspected that their data was being processed inappropriately by a US security agency, they had a mechanism that they could, you know, ask, is this happening? And I want my data to be deleted if that is happening. But the trigger for that wasn't clear to me. So, like, if you like, what causes you to have suspicion that your data is being processed by a U.S. security agency?
Yeah, what's the confidence bar, basically? Is it any suspicion I have a bad feeling and I want to just check?
And in the chat that we had, or in the presentation, they offered some examples about why you might think that. But then somebody asked, well, you know, do you have to wait for one of those triggers, the example triggers that they offered? Like, what if somebody just thinks that their data might be processed by a U.S. security agency? Because, you know, I think people around the world just think that U.S. security agencies process data on every person in the world. And I don't know. I'm not Edward Snowden. I don't have any insight into that.
Yeah.
But so they said no, like, you just a suspicion without other grounds was enough. But what happened then was some sort of an internal investigation would occur, and you would just get something back that says, if we were processing your data, now we're not, and we're deleting it because you asked us to, or something like that. And again, I might be getting it wrong, but that was the essence that I got out of the presentation, which seemed wishy-washy to me.
Yeah.
Because you know, if the rule is that the U.S. security agencies shouldn't be processing that data, they shouldn't be. But the reality also is that there are foreign nationals around the world whose data we really should be processing, because we have to protect ourselves as a nation. And I think the same is true of countries in the European Union. Like, they have, I don't know, terrorists and stuff from other countries that want to do harm to their countries too. And their own internal security agencies want to do research and gather data about people around the world who might want to do them harm. So I'm not sure where to go there. Like, at some point you have to realize that the governments have security agencies who are there to protect us as a country, and in some ways to protect, I don't know, democracy worldwide, or whatever. And I think that when our security agencies find information from people in other parts of the world that are relevant to threats in other parts of the world, they'll share that with those countries. Right. I hope, and so I don't know. It's just a part of life, knowing that there are governments and security agencies spying on us. It's just part of what happens.
It's kind of an endless spiral of, you know, who has the best interest for who, right? You know, right. A government of a country or a group of countries is going to prioritize their own, you know, cultural incentives, their own, you know, mechanisms for what they think is right and what they think is overstretching. And I think the EU has done a really good job of, not always just attempting, I'll say at least attempting, if not pushing through really good and protective frameworks with a lot of great, you know, the essence is in good faith, right? Like, their intentions are great. The practicality of it, when you're running up against, you know, how the US has developed information technology over the last 20, 30 years, how China's done so. I mean, they're very, very different incentive systems and structures, but we have the tools now in place that we didn't before, when all of these things were of interest, like you said, monitoring foreign threats. Well, when the whole internet is shared across the world, the companies that distribute those technologies are almost all the time globally situated. How do you
Yeah.
comply to those requirements when you're not wholly, dedicated to one country's, interest in collecting data or another? And that's where I say it becomes a spiral, right? It's like
Yeah.
never ending problem framework that only responds to what we found is unsavory, and in a lot of cases the EU's perspective, because I think the EU, like I said earlier, does a really good job of almost exporting these frameworks and these requirements to other countries wishing to improve their data protection practices. But in reality, it gets a lot more complicated with that, because nothing is truly domestic anymore, right? We share our infrastructure, we share our technologies.
It's true. And I think that it goes back to the question, like we've talked a lot about the fact that there isn't a comprehensive privacy regulation in the United States. And because of that, there's a lot of states that are enacting state privacy regulations. There's, we've talked about them, it was like 6 of them right now, but there's like 12 more that are in the works. So we're going to have this patchwork of state privacy regulations. But if you look at that on a global level, what's happening now is, I think GDPR kind of became the template, but there's countries around the world that are enacting privacy regulations, and a lot of them are very similar to each other. But when it comes to this cross-border data transfer aspect of it, having that patchwork of regulations around the world is going to make it very, very difficult, because I think that more countries are going to do that. I was investigating today to see if the US was considering putting something like that in place to protect data that's leaving the US, because like we said earlier, there's no protection against that. And I couldn't find any suggestion or indication that there was anything in the works to try and implement something like that. But clearly other countries are. So just like we need a comprehensive internal privacy regulation as a country in the United States instead of the patchwork of states regulations, is it possible to have an international data transfer agreement like between
that seems to be
countries?
the immediate first solution to me, but also, like, ironically, the most impractical
Difficult.
given the current environment, because then
Yeah.
you start encroaching on problems like intellectual property development. I mean, data sharing data, is a very valuable commodity, and to get every country in the world to agree on one single framework means compromising any competitive advantage that they might have with certain alliances, or with restrictions even on imports and exports of data, just like any other commodity. And I think that's, and I have to assume, again, not a lawyer and also not trying to bring too many politics in this conversation, but I assume that's why we are becoming more sensitive with overseas technology from China, say social media, coming over to the US, even if they are siphoned off, the storage and the networks that we use to communicate through them. We are still very apprehensive about, trusting without just verifying and seeing all of the due diligence performed beforehand. And I think it, yes, applies to both, the Chinese Communist Party's past practices in their relationship with their companies, tech companies.
Yeah.
And ours, they might not differ too much on the surface, but the US and China just have way different incentives behind their technological development. They both want to be the leaders in AI and everything software and hardware related, but there's not a partnership right now. There are kind of very contentious agreements, but I think introducing technology that gives a direct access to things like our, the social media networks that citizens are exposed to is a very understandable concern. But that agreement would have to happen, or some an international agreement. We would have to come to one with China, say, for those issues first, which seems like a very large uphill battle, especially when we're focusing on privacy right now, and we do have technically a patchwork of transfer agreements in place that are doing the job until we do get scrutiny and we go back and revisit the drawing board.
Yeah, I mean, definitely the gap between those two countries, the US and China, when it comes to that regard, it's a pretty wide chasm. And I think it's interesting that I mentioned earlier that China has a relatively new it's called their Privacy Information Protection Law, or PIPL, was enacted in 2021. But one of the provisions of it essentially requires that processors of data who are going to send it out of China have to essentially be inspected by, I think it's the Cyberspace Administration of China. So they have a specific arm of the government to do that. But in order to ensure that these companies have adequate privacy and security practices, they have to get inspected by the government, which in and of itself, you would say, well, that's a bit of a violation of privacy. But I think that that's not what they're concerned about. So
yeah, it's how
they
don't behave. Yeah, they're a very state-driven regulatory model. I mean, the CCP is very much either a part of a lot of these tech companies in the form of their founders, or vice versa, where there's just an inseparable relationship between the two, because China has very much an authoritative regime going on, where they do prioritize social stability and economic development within their own country over other priorities, which inevitably compromises things like partnerships with the US that are unfettered and unregulated. And I think it makes sense for them to produce those types of requirements in that regulation.
Yeah, well, and looking at a hopeful sign, there does seem to be a push to soften some of the regulations in the Chinese personal information protection law. And one of the new exceptions that's being proposed is an exception for cross-border data transfers that are necessary for protecting the health and property and safety of a natural person in an emergency, which you would hope that in an emergency, like if somebody needs to be life flighted out to somewhere else, you're not going to have some privacy protection law that's going to prevent their medical records from going with them, for example. So I like that there's reasonable exceptions being added to it. And I also thought it was interesting that the term natural person is the term that they use in their own law, which kind of mirrors GDPR. Like GDPR was the first place that I saw.
It goes back to the whole, their regulations are basically a form of technological exports, right? There isn't a group in the world that's done as much research and invested as much in developing the higher level principles that address the problems that have been unveiled in the last 20 years, other than the EU. So it just validates my interpretation of the world to that regard.
Yeah, maybe as privacy professionals, we're working in the wrong continent. Maybe we belong in Europe.
Yeah, I mean, we study enough of it with not living in that regime, so I think I would do fine over there.
Well, okay, so maybe there's some good companies in good parts of Europe that are looking for really good privacy professionals, and they're going to reach out to us because they've been listening to our podcast or something. But I'd have to talk to my wife. I don't know that she's ready to move to Europe right now.
Yeah, anyway. You've been there once at least.
I have, yes, I've spent time there. Okay, I don't know. Is there more?
We covered enough?
I think so. I think we've tried to make a commitment to our listeners that we're not going to go over, and I think we went over. But so I could keep talking about this for another hour or two with you, but we won't do that to our listeners. So if we have more, we'll add it to another episode, which we have to figure out what's next. We don't have anything teed up yet.
Yeah, I guess this is an opportunity for feedback for anyone listening, but I'm sure we'll get somewhere. We do have a backlog, and I think it's a matter of flipping a coin, closing our eyes, throwing a dart. Certainly not at our computers, but
I have ideas, but we'll talk. So
cool.
But anyway, I'll say thank you to anyone who's listening. Thank you for tuning in.
Yes, thank you to everyone listening, and thank you as always, John, for the great chat and the research beforehand.
Thanks, Rachel.
What's up?
Good to talk.
Bye, everyone.
Bye.